Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we are talking about color of right. Cases that should have gone to the Supreme Court of Canada, but didn't. Color of right is a legal defense that applies in circumstances where a person is accused of having stolen an item, but claims that they had a legitimate basis to believe that they had the right to possess that item. Sean Horse was charged with theft involving a cell phone. The story goes that Mr. Horse had gone up to Miss Lalonde, asked to borrow her cell phone to try and get help searching for his lost dog, and then took off running with the phone. A pursuit ensued. He dropped the phone. Miss Lalonde recovered her phone, but Mr. Horse was later arrested by police and charged with theft. At trial, he argued that he had the color of right to possess the phone and to take off running with it because she had loaned him the phone and he believed that he had the right to have it because he was borrowing it. The trial judge accepted that he did have color of right as a defense to the initial possession of the cell phone, but once he took off running, the defense no longer applied on the basis of the fact that he was in the course of stealing it in that circumstance. And this case raises important issues because it deals with the question of whether continued possession of an object that you have legitimately borrowed and that you have legitimately raised the defense of color of right about possessing actually continues to apply even after the person revokes their consent for you to have the item. In those circumstances, you end up mixing these civil and criminal law concepts like whether or not something has been loaned or given, or whether or not something is being retracted, a gift being taken back. And these are very important issues that the Supreme Court of Canada could have sorted out. Ultimately, we don't actually have a legal definition in this country of when color of right specifically ends and when a person is therefore then guilty of theft. And that's something that the Supreme Court of Canada absolutely should have delved into and given more clarity on, because these types of distraction thefts are common accusations made in our criminal courts, and the issue of color of right often comes up in these types of cases and in circumstances like this. And the Supreme Court of Canada could have had the chance to clarify specifically whether there is a line between when the defense begins to apply and when it ends applying, or whether or not it's different in every circumstance of every case. And they missed that opportunity here. This means that a lot more people who are charged with theft, who may or may not have legitimately believed that they had a right to hold the object or have the object that they're accused of stealing, have to go through the expense and the effort of a trial without certainty about this area of the law. And that's the type of thing that the Supreme Court of Canada should have chimed in on. Unfortunately, it's going to take another case and another person who's potentially innocent of a theft allegation to test the waters of this defense in our court system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.